So good morning, everyone, and welcome to our TUPE Club webinar. I'm Siobhan Bishop, a Principal Associate in the Employment, Labour and Equalities team here at Gowling WLG, and I'm delighted to be joined by Jane Fielding, who is a partner in the team and the head of the team, and also Hannah Swindle, who is a Principal Associate. So today we're going to be taking TUPE back to basics. So we've designed this session specifically for those who don't have much experience in TUPE or perhaps would like a refresher. We'll treat it very much as an introduction to all the fundamental concepts and the key issues, and with some tips about how to avoid liability as well. So if you don't regularly deal with this, we're hoping that that will be an ideal session for you. I'm sure you'll know TUPE is a challenging area and there's a lot to cover. So the way we're dealing with this is almost in two parts. Today we'll do the back to basics, and then later in June we'll have another webinar where we'll dig into the details in more information and give you more information and examine some of the issues, especially the more complex issues, more carefully. So what's on the agenda today? We've first of all got what is the effect of TUPE. So that's the effect on the employees and the risks that it creates. And we'll also look at what Brexit means for TUPE going forwards. When does TUPE apply? So that's a key question, both in terms of a sale and acquisition of a business and an outsourcing situation. TUPE and information is one of the key practical things that you have to look at. So we'll look at how and when that applies. And finally, wrap up with some mitigating risks, so helping you to avoid liability for the key issues in a TUPE situation. So we're aiming for an hour today. We'll run through the presentations first, and then there will be time for questions at the end. I'm going to disappear off screen to marshal those questions so we can answer them, or as many of them as we can, at the time at the end. But you can submit your questions at any point during the webinar using the Q&A box, and we'll deal with those as speedily as we can to get through them at the end. So I'm going to first of all hand over to Jane, who will be dealing with what is the effect of TUPE.
Thanks, Siobhan. So, TUPE, Transfer of Undertakings, Protection of Employment Regulations 2006. If you remember nothing else about this talk, remember the bit in brackets, protection of employment, because that is how tribunals, when they look at TUPE, will generally interpret any ambiguity in the provisions. It's all about safeguarding the rights of employees when there's a change in ownership of the business in which they work, or there's a change in service provider for any services in which they're engaged. So it's all about looking after people when they get moved with the employer's business or services being provided. Now, originally, TUPE came from Europe, so the Acquired Rights Directive we've had since 1977. It was updated in 2001, and TUPE 1981 was when we first started grappling with this in the UK. That was replaced in 2006 with a new set of TUPE regulations, and those are the ones that we use today. They were updated in 2014, but it's still the TUPE 2006 ones that are the main regulations. And then obviously overriding all of that and helping us understand TUPE is a constant stream of case law, both domestic and European. So there's a lot, as Siobhan said, to get to grips with in TUPE, and for a relatively short set of regulations, it can get quite fiddly. And clearly, because it's law from Europe, we also need to look at what the situation is now we are post-Brexit. So, as I'm sure you all know, the EU Withdrawal Act 2018 is the relevant piece of legislation here, and it set what's called this implementation period, which ended on the 31st of December last year at 11 o'clock. And that's a key date for understanding what happens in terms of retained EU law, as it's called. Now we are post-Brexit. So basically what the Act does is it freezes EU law that was applicable in the UK immediately before that December date. And what it requires our UK courts to do is to follow European CJEU decisions that were taken before that date, and they are given by that Act the same status as Supreme Court decisions. But there are certain UK courts that can depart from that case law if they think it is right to do so. And those courts are the Supreme Court, obviously, but also the Court of Appeal and the Court of Session in Scotland. That's where it stops, though. So the Employment Appeal Tribunal, which, as you all know, is the first instance appeal court after the Employment Tribunal, doesn't have that ability to depart from pre-IP EU cases. It's only the Court of Appeal and the Supreme Court. And most TUPE cases don't actually really get beyond the EAT. There aren't that many like there are with discrimination or whistleblowing cases that go beyond. So it'll be interesting to see how long it takes for any pre-IP EU cases to be departed from, because they've got to get at least to the Court of Appeal. In terms of future decisions of the CJEU, the basic position is that our domestic courts are not bound by post-IP principles or cases. So they don't have to follow future decisions of Europe, but they can have regard to it if they consider it to be appropriate. So what do we think about future changes in the area of TUPE? Well, in the Trade and Cooperation Agreement, there is this non-regression principle and it does apply to employment law, so it will apply to TUPE. And what that says is that basically, if the UK diverges from EU law at any point, and that affects trade and investment or impacts on trade and investment, then the EU could trigger a dispute resolution mechanism. And it's not unlikely potentially, or it's not impossible to see a situation where we might water down TUPE, water down the effects of the protection of employment rights, making it perhaps cheaper to employ people, less onerous to take on a workforce, and that potentially could impact on trade and investment, and therefore get into this sort of dispute resolution mechanism. But it's very early days and too early really to predict whether that's going to happen. Certainly, we've not seen anything coming out of the department for exiting the EU indicating any intention to do anything around TUPE, but it is a possibility. So that's all I want to say about Brexit. In terms of the effects of TUPE, what does it do? So I mentioned it's all about protecting employees, and it does that in a number of ways. So firstly, employees who are assigned to the business or the services in question will automatically transfer. And Hannah's going to look in a little bit at what assignment is. But the basic principle here is that people move across with their work if they're assigned. Now, it's about protecting employees. So it's not that this happens with no ability for them to say, I don't want to go. So enshrined in TUPE is each assigned employee's ability to opt out or object to transferring. They can't be forced to work for somebody they don't want to work for. So that's a key part of TUPE. They move over on their existing terms and conditions, so they're preserved. And also, if they've got any claims against the transferor or the current employer, then those go across as well, and the transferee inherits those. So they might have a claim for underpaid wages, they might have a harassment grievance ongoing or a claim. The transferee steps into all of that. And in terms of collective issues, if there are collective agreements in place between the transferor or employer and a recognised union, and those provisions flow down into the individual employment contracts of the employees who are transferring across, then they will be inherited by the transferee as agreed at the point of transfer. So if there's a 2-year pay deal agreed, for example, and they're only 6 months into that, the transferee will inherit the obligation to increase the pay as agreed over the 2-year period. They're not caught by any changes agreed subsequent to the transfer if they are not in their own right party to that bargaining at a collective level. And if there's trade union recognition in respect of the staff who are transferring over, and the organised grouping of resources or the organised grouping of employees that is the sort of fundamental part of whether a TUPE transfer happens in the first place, which Hannah's going to cover. If that's in place and it maintains a distinct identity in the transferee organisation, then the transferee can also inherit trade union recognition, although it is on the same basis as the transferor. So if it was voluntary, they could be recognised as a matter of law, although there'd be industrial relations issues arising out of that, of course. Now, as I've said already, the transferee effectively steps into the transferor's shoes in respect of all the rights, powers, duties and liabilities as between it and the staff. But there are some exceptions to that. The first exception is criminal liabilities. So in contrast to civil or tortious liability, criminal liability can't transfer. So that might, in this context, be around immigration checks. There might be criminal issues around tax, something like that. That stays with the transferor. And the second big exception is pensions. So old age benefits under occupational schemes don't transfer to the transferee, but early retirement and enhanced redundancy benefits under that type of pension scheme, which can be very generous, can transfer. Those are the sort of Beckman and Martin rights, which you might have heard about, and they're very complex. Luckily, we have an excellent pensions team, so if anything comes up like this, then we always involve them, because these can be very significant liabilities, and it's really important to understand where they might fall and how they're valued. And private pension contractual obligations of the transferor do transfer. So, for example, if you've got a contractual clause that says the employer is going to contribute 10% to a group personal pension scheme, then that will transfer and the transferee will need to be funding that. So a few more effects of TUPE. Again, bearing in mind this is about protecting employees. Changing terms of employment becomes more difficult in a TUPE context. So as I said just now, the staff go across with their terms and conditions intact. Now, there might be a right in the employment contract to change terms that the transferee can use, but those tend to have to be approached with caution anyway, because the extent of that right may be open to challenge. If you don't have that in a TUPE context, it's very difficult, and there are very limited circumstances in which a change is allowed, even if the individual employee consents. And the effect of the change not being valid is it's void, and that can cause difficult complications. So this changing terms of employment is a tricky area in TUPE, and one we'll come on to look at more in the next session that Siobhan mentioned that we're going to do in June. The second key protection in a TUPE context is enhanced protection for unfair dismissal. Now, employees still need the 2-year minimum qualifying period to claim unfair dismissal, but if they have that qualification, then the situation is that there's automatic unfair dismissal if the sole or principal reason for the dismissal is the transfer itself. If it can be shown that there was an economic, technical or organisational reason for the dismissal, which involved a change to the workforce, so that's either a change to headcount or a geographical relocation, then it's not automatically unfair, but we revert to normal unfair dismissal principles to see if the dismissal is fair or not. So that automatic unfair dismissal, if the sole or principal reason is the transfer and it's not saved by an ETO reason, is very valuable. And it means however lovely a process you follow in terms of consulting about the dismissal, it doesn't matter. If that link is made out, then it's an automatic unfair dismissal finding. And then the final protection for employees is around providing information. So there's obligations around employee liability information. That's from the transferor to the transferee, so that they understand more about what they're inheriting, what the rights and obligations they have towards the staff are, so that they can honour those. And then the second aspect of information is that the staff are entitled to be told and consulted about the proposed TUPE transfer and the impact of it via employee representatives. And I'm going to come on to look at both of those things in a little bit more detail. What I wanted to say first, though, is that the information and consultation obligations in terms of consulting with employee representatives are wider. They go wider than just consulting and informing the individuals who are in scope to transfer. They apply to anyone who's affected by the transfer, any affected employees. So it's important to bear that in mind because there's not a direct correlation there. But I'm going to come on to that later. And first, I'm going to hand over to Hannah.
Okay, so I am going to take a little look at when does TUPE apply, which is the always the million-dollar question. We spend a lot of time helping clients to identify the risk of it applying, but there's never 100% certainty of that. So sometimes we have to just take a view and proceed on the basis of whether it will or it will not. But to be able to get to as certain a position as we can, we need to look at the legal framework. So on the slide there, we've got the initial part we need to look at. TUPE applies where there's a relevant transfer. And there are two types of potential transfer. First of all, we've got a business transfer. And the classic example of that is where you've got a business being sold as a going concern. And the other type is a service provision change, which involves outsourcing and a change in the provider of services to a client. But these types of transfer do overlap, and it can be possible to be both types at the same time. So it's always important to consider both types. So if we're looking first at a business transfer, and it's often called an old style transfer because it's been with us since TUPE first came about in 1981. So for there to be a business transfer, we need to have a transfer of an economic entity or undertaking, or part of one, in the UK to another legal person or company. The entity or undertaking also needs to retain its identity after the transfer, and I'll look at each part of that definition in a bit more detail in a moment. But here, as shown on the diagram, there's going to be a transfer of employees from the seller or the transferor to the buyer or the transferee. So if we break down this definition into a bit more detail. So first of all, for TUPE to apply, we need to have an undertaking or business or part of an undertaking or business in the UK. Then there has to be a transfer of the running of that business or part of business to another legal person, which is usually another company. And often in a business transfer, there will be a purchase or sale contract. But importantly, there is no need for a contract between the two parties. So the important thing is to look at the start and end point of where the work or the business is moving to and from to identify whether a transfer has taken place. TUPE doesn't apply to the sale of shares, but a little bit confusingly, there is potential for TUPE to apply before or after a share sale if there's any intra-group reorganisation to move parts of the business to another part of the group. So what exactly is an economic entity? It's an organised grouping of resources pursuing an economic activity. It doesn't matter whether that economic activity is central to the business or just ancillary to it, but you need to be able to identify it and for itself. It's still quite confusing as to what this actually means. But clearly what we know is it's not just a collection of assets. So when does it tip over into something more than just assets? It's often clear, for example, where you've got a sale of a whole division of a business, or even more obviously, all the assets of a business to a single buyer. But where you're splitting assets between different buyers, it becomes more difficult to work out. And so you need to look at each split in detail, and you need to ask the question whether there's enough for it to be an economic entity. And that might depend on what asset is included in the sale based on the nature of the business. So in a software business, that might be the IP. In a cleaning business, where are the people going? And land in a farming business, for example. And for TUPE to apply, that undertaking or economic entity has got to retain its identity post-transfer for TUPE to apply. So the test that is used to work this out is often called the going concern test. All the relevant factors must be looked at, including what has actually transferred, goodwill assets, and including, importantly, which assets. And I've just mentioned that certain ones are going to be more important for different types of businesses. You also look at how similar the activities are before and after the transfer, and whether there's also a transfer of employees and customers. And finally, we also know from case law that an entity can retain its identity even if it's integrated into the transferee's business after the transfer. The second test in TUPE is one that came about in 2006, largely to address the fact that the old test had started being applied as a matter of case law to outsourcing. So this service provision change test was brought in to try to give a bit more certainty in outsourcing situations. And it's going to apply in 3 scenarios. The first is an outsourcing of services from a client to a contractor. So that's where activities are being carried out by a client on its own behalf, and then they decide to have a contractor do those services for them going forward. Secondly, it can apply where the client has decided to change that contractor or switch to a different provider. And that's sometimes called a second generation outsourcing, where the services are transferred from one contractor to another. Finally, it can apply to an insourcing, where the client decides they now want to do that activity back in-house and they insource it. The slide shows the typical model in an outsourcing service provision change. You've got the client at the top, the customer for the services. Then at the next level down, the service providers or suppliers, so both the outgoing and incoming employers. And where there's a change in service provider, the TUPE transfer goes directly from the outgoing provider or supplier to the incoming provider or supplier. But there's not actually a direct contract between these 2 providers, and TUPE works independently from the actual contract. Instead, the contracts are between the service providers and the customer, but the customer itself is not a party to the TUPE transfer. And this is really important because it impacts on how the indemnity protections work. Indemnities are usually included in a contract where TUPE applies to protect the incoming employer from inheriting liabilities arising from the acts of the outgoing employer, because otherwise, as Jane has already mentioned, they transfer over automatically with the employees. And instead of the indemnities going directly between the outgoing and incoming employer, as they may do in a business sale, they will be between each supplier and the customer. And we'll look at the issues around drafting in more detail in our next TUPE session in June. So in a bit more detail, the conditions for a service provision change are that you need an organised grouping of employees who are situated in Great Britain, and their principal purpose needs to be carrying out activities on behalf of a client. It's also necessary that the client intends that fundamentally the same activities will continue after the transfer. And that's always a question of fact. The parties need to look at how the activities are carried out in practice and also what the contract says. There are a couple of key exceptions to be aware of that have been written into the legislation. A service provision change doesn't apply to contracts wholly or mainly for the supply of goods for the client's use. Government TUPE guidance gives the example of a contract to supply sandwiches for a client to sell to staff in its canteen. This will be covered by the exemption, so TUPE won't apply if they change that contract or retender it. But if you contrast that with a contract to run the staff canteen, that means the activities would not be wholly or mainly the supply of goods, it's a service, so TUPE would apply there. The second exception is that it will not apply to contracts for a single specific task or event of short-term duration. And case law has confirmed that the 2 should be read together. So we're referring to a single specific event of short-term duration. Government guidance again has given us an example, and they gave the example of the supply of security services at the Olympic Games. It's a question of fact and degree what is short-term, and the client's intention immediately before the transfer is really important. You can't use it to get around TUPE just by entering into a succession of one-day cleaning contracts, for example. So once we've worked out that we do have a TUPE transfer, next we need to think about who it's going to apply to. And in the regulations, it states that TUPE applies to all employees assigned to the organised grouping or transferring undertaking. They don't helpfully define assignment in the regulations. All they state is that it's other than on a temporary basis. That's going to be a question of fact in any one case. So it's important to look at a number of different factors to work this out. None of the factors are determinative in and of themselves. You've got to look at them all together. And at the slide, we've set out the various factors that are most commonly considered. At the top there is time, and we often get asked whether someone will be assigned for TUPE purposes if they work more than 50% in a business or on particular services. It's a good starting point, a rule of thumb, to identify the people who are most likely to be in scope, but it's not simply just a question of how much time they spend on that particular business or service. It is a factor, but it's not determinative. We also need to consider things like the nature of the work. What does it say in the employee's employment contracts? But also importantly, what do they do in practice? What are their actual day-to-day responsibilities? Allocation of cost can also be relevant. Is the cost of an employee allocated to a particular client contract, for example? And then we also need to look at the value of that individual for the service or the business in question. What we do know is that someone has got to be assigned other than on a temporary basis. So TUPE is not going to apply to a temporary secondee, but it would apply to someone who's made a permanent transfer, even if that's relatively recently. The tricky areas often come about where employees work on more than one contract or for more than one client, such as a project manager or possibly in a shared service team, such as HR or IT, which supports lots of different parts of the business. And in those cases, it's really important to consider all the factors, including that type of job role. A project manager won't necessarily be assigned to a contract just because they're spending all of their time on that contract in the lead up to transfer troubleshooting. And it can also end up to be the case that employees are not actually assigned to any particular contract. Thank you. I'll pass you back to Jane now.
Thanks, Anna. So I'm going to pick up on information and consultation, as I mentioned earlier. And firstly, the obligation on the transferor to provide employee liability information to the transferee. And this is to help the transferee understand what they're in to inherit in terms of the number of people, the profile of the people, what basic terms and conditions they are on. So I'm not going to read out all of the particular categories of information on the slide, but they're set out there and you can see more detail in Regulation 11 of TUPE. But what you can see is that it does require a degree of organisation and coordination by the transferor to pull that information together to pass on at the appropriate time to the transferee. And generally, in our experience, some HR departments are excellent at capturing that information if they do a lot of TUPE work. For some, if TUPE is a less regular occurrence, it takes some time to pull that together and to make sure that you're getting the right information. So some degree of organisation and coordination is very helpful there. So what do you have to do with this information? Well, you have to give it to the transferee at least 28 days before the transfer takes place, or the date you expect it to take place. And if you provide the information in compliance with that obligation under Regulation 11, then you have your data protection basis for doing so, because you're complying with that legislative obligation. If you don't comply as the transferor, what's the potential liability? Well, it's just an equitable compensation which the transferee can be awarded if they put in a claim to the Employment Tribunal, and it's at least £500 per employee for the failure, but the tribunal will take into account the provisions of any indemnities that are designed to protect in this area. And I've said on the slide there that it's really too little too late. The reason we say that is, in terms of it being too little, you can see from the list that it doesn't cover some very important aspects that the transferee might be interested in terms of the employment contracts of the staff. So it doesn't cover whether they have enhanced redundancy protection, and if they're looking at reducing headcount, then that could be very significant. It doesn't cover, for example, if they have valid restrictive covenants in place, and if you are in a business sale situation, that could be particularly significant. So there are some key areas which a transferee would be interested in, which they're not going to get just as a result of compliance with employee liability information obligations. And that's why we quite often see them supplemented by the customer in an outsourcing, for example, by contractual provisions to try and flush out more information. And that's also relevant, and the reason why we have those provisions in terms of timing, because if you're looking at a large workforce or a large scale retender of services and a long tender process, then 28 days before the transfer is going to be too late to help potential bidders, if you're in a tender situation, shape their bids, understand their pricing, etc. And so those contractual provisions requiring the incumbent contractor to provide information, usually on an anonymised basis, because that helps with data protection impact, to provide that information much earlier in the process, that's very helpful in that sort of situation. Moving on then to the other key aspect of this, which is perhaps more obviously for the benefit of the employees affected. These are the obligations to inform and consult, and they are distinct obligations. The obligation to inform applies in every TUPE situation. The obligation to consult is only mandatory where the employer envisages measures, and we'll come on to look at what measures mean in a little bit. But even if there are no measures and the obligation to consult is there, what case law tells us is that you should still leave time in the timetable for voluntary consultation to take place. So effectively, a gap in the timetable, you've informed, but before you actually go ahead with the transfer, allow some time for the staff via their reps to raise questions, make comments, etc. But it's not an actual obligation in terms of mandatory consultation. And the obligation, as you can see on the slide, is to consult with appropriate representatives. And Regulation 13 tells us what that means. And basically, if there is a trade union that's recognised in respect of the affected staff, so if they're all in the same bargaining unit, then the trade union is the appropriate representative. However, if there's no trade union, or there is a trade union, but recognition is only in respect of part of the affected staff group, so the bargaining unit doesn't cover all the affected staff, then for those staff that aren't in the bargaining unit, or if there isn't one, then the employer has a choice. They can either consult with staff reps who are pre-elected, so there might be an existing staff forum, for example, as long as the purpose for which they were elected is wide enough to capture TUPE, and it won't always be, but if it is, then that's an option. Or they can choose to invite the staff to elect reps specifically for this TUPE exercise. And that's generally the safer option, because you don't need to worry about whether the pre-elected forum has standing or whether individual members are still within their term of office, for example. But if you do invite staff to carry out an election, then obviously there's a knock-on effect on the timetable for the TUPE transfer, because you have to build in time for those elections to be conducted. So what information do you actually have to give the affected staff? Well, it's there on the slide. It has to be in writing, but otherwise it's fairly unprescriptive how you provide it. And it's basically, as you can see, letting the affected staff know about what's being proposed, what it means for them, why it's being done, and just focusing on the last two bullet points on the slide there. These are where we have to talk about the measures that are envisaged by the transferor or the transferee. And if there are no measures, confirmation of that. So what does measures mean? Well, it's not defined anywhere in TUPE, which like many things in TUPE is not that helpful. But what case law tells us is that it's any positive act or omission by the employer, and it's a very low threshold. So, for example, there have been cases where it's only been the payroll date that has changed, and that's had a slight impact on deductions made to salary, sometimes in favour of the employees, not necessarily to their detriment. But even that counts as a measure that should have been informed and consulted about. And finally, you have to provide specified information about agency workers who are working in the business. And that seems slightly odd in a TUPE context. There's a mirror obligation in the context of collective redundancy consultation, where it makes more sense, because in that situation, the union or the elected representatives might be saying, well, why don't you, rather than make employees redundant, why don't you look at letting the agency workers go first? So in that context, it makes a lot of sense. In this context, slightly less so, but it is there. And if you don't provide the information, there is case law precedent to show that penalty, which I'll come on to in a minute, will still apply. So basically, you have to be telling the representatives how many agency workers there are, which part of the business they are working in, and what type of work they do. So moving on to consultation. When do you have to do this? Well, you have to do it, again, a nice vague TUPE term, long enough before the transfer to enable meaningful consultation to take place. So that basically means in good time for it to be an effective process, really. But it's of course going to depend on how many people are affected and the number and extent of the measures that are being proposed. And here I just wanted to flag a slight oddity really about TUPE potentially, which I think people get confused about. The obligation to consult about measures is only between the transferor and its own staff and the transferee and its own staff. So they both have separate obligations towards their existing staff who might be affected to inform, and then if they propose measures in respect to those staff, to consult. There's not actually any obligation on the transferor to consult its employees affected by the transfer about the measures proposed by the transferee. But what happens in practice, because it's best practice to look after the staff generally, is that the transferor will invite the transferee in to talk to the staff who are going over about what they propose. That's what happens in a best practice situation. And there's a separate obligation on the transferee to comply with a duty to confirm what measures it envisages to the transferor, so the transferor can pass that on to the appropriate representatives. But as I say, there's not actually any obligation on the transferor to then consult, but often they will facilitate a process voluntarily or because they're required to do that by a customer contract in an outsourcing scenario. In terms of the penalty for getting this wrong, well, the maximum penalty is 13 weeks actual gross pay per employee affected by the failure. So a good shorthand for that, which can get the attention of the finance director in particular, is it's a quarter of the annual wage bill for the affected employees. That's if you do nothing. If you do something, then you have the ability to argue down from there to what is just an equitable compensation. And for the transferring staff, the ones who are going to go over to the transferee, any award is made on a joint and several basis. So the individuals can choose who to go against. But if the only default is because the transferee did not give the transferor the measures information, and therefore the transferor couldn't pass that on to the appropriate representatives, then in the event of a claim, the transferor can join in the transferee and push the liability back onto the transferee, because it's that default is their fault and therefore should be their liability. And the last thing I wanted to measure on this is we quite often get asked, well, you know, it was really late, we were getting pressure from our parent company, we were in an insolvency situation, do we really still have to do this? And the answer is basically yes, you should really try and do whatever you can in the time available. There is a special circumstances defence, but it is only very exceptionally applicable. And in practice, we would generally recommend not paying too much attention to that, because it's very difficult to bring yourself within that situation. So to bring that penalty down, it's really advisable to do whatever you can in the time available, even if you can't do a full information and consultation process. And I will now hand over to Hannah, who's going to talk about mitigation.
So because of the automatic transfer principle of TUPE and the additional obligations that it places on the outgoing and incoming employer, it can result in potentially significant additional risk and costs. And the main areas in which risks can arise are set out on the slide. So first of all, we need to consider the employees involved. Parties need to know who will transfer. So if you're the incoming employer, it's important to try to obtain information about who you're going to inherit. You may need to know you have enough staff with the correct knowledge to be able to be up and running with the services from day one. Are there any key employees you want to make sure are transferring? If you do not inherit the correct employees, that could impact your ability to meet service requirements for your customer. And so you also need to ensure that you're aware if anyone is temporarily out of the business. For example, anyone on sick leave or family leave, because they will still transfer. If you're the outgoing employer, you'll need to know what the remaining workforce is going to look like after the transfers happen. It's less of a problem where you've got an entire service being outsourced or moved to another provider, and it's clear which employees work on those services and therefore who will transfer with it. But it's more difficult where only part of a service or business is going to transfer, and if you've got employees who work across the entire service or business. Are you losing any key employees yourself? Because if you are, and you want to make sure that they're retained, you'll have to consider ways to do that. For example, you might move them into other parts of the business before the transfer. And we'll be looking at practical issues like this in a bit more detail in our June session. So the next point on the slide is more of a problem for the incoming employer. As we've heard, the employees transfer across with all of their pre-existing rights and liabilities, with a few exceptions for pensions and criminal problems. So the incoming employer must work out how to replicate benefits that the employees are entitled to. And that can often be a problem, especially where you've got insurance type benefits or where the employee is entitled to benefits which are linked to the outgoing employer's business. So for example, access to a share option scheme. The incoming employer has also got to consider if there are any pre-existing issues in the transferring workforce that need to be dealt with. For example, such as long-term sickness absence or ongoing disciplinary issues. The next point there is information and consultation. Jane's already mentioned that potential maximum liabilities are 13 weeks gross pay or a quarter of the wage bill if you get it wrong. So it's really, really important to build in sufficient time to any transaction or transfer to make sure you do a proper process. And finally, it's important to work out if there are any risks which arise due to the specific deal you're working on. So for example, this might be issues such as a transferring workforce with large amounts of accrued holiday, or maybe transferring employees are entitled to a really generous bonus, or if you're going to have to do a lot of redundancies to right-size the service right at the start. And I'll come on to later how we might deal with those in a moment. So there's a few more examples of risks that might arise. It might be the case that after the transfer, the incoming employer wants to make some changes to terms and conditions of employment or working conditions. They might need to fit in with existing shift patterns, for example. So first of all, it's important to remember that any proposed change is going to be a measure, and that needs to be consulted about, even if it doesn't consist of a contractual change. Jane's mentioned that claims can arise if employees don't like the impact of the change, and there might be potential issues making sure that any contractual changes that are put in place are valid. And we'll discuss in more detail in our next session in June those types of risks and how we can actually make some valid changes. Redundancy situations often arise in connection with a transfer. That can result from the incoming employer ending up with too many employees post-transfer than it needs to carry out the work going forward, or maybe because they operate from a different location and you can't either require the staff to relocate or they don't want to. The outgoing employer might also have a potential redundancy situation in its retained population because it's got a reduced need for staff after losing contracts that the employees worked across, for example. In all cases, redundancy dismissals need to be carried out fairly, or you've got a risk of claims. And again, just to flag, post-transfer redundancies are also going to be a measure. Where it's an outsourcing situation, there's an added level of complexity. I've discussed earlier in the session, there are 3 parties involved, but where you've got that transfer taking place between the outgoing and the incoming providers, only one of them is going to be a party to the contract with the customer at any time. So outsourcing brings its own challenges because of that tripartite nature of the arrangement. And because where there's a change in provider, the incoming employer doesn't have any direct indemnity protection from the outgoing employer, as you might have in a business sale. But all those indemnities have got to be flowed through the customer. So as a customer enters into a new contract with an incoming supplier, it's got to consider what indemnity protections and rights it currently has under its existing contract with the outgoing supplier, and also look at what obligations it's subject to. It might be asked by an incoming supplier for indemnity protections in respect of liabilities connected with those transferring staff. If the customer doesn't have those in its existing contract with the outgoing provider, then it's going to be left exposed if it gives them to the incoming provider. But commercially, the incoming supplier's got to account for that risk. It's going to inherit all of those problems automatically under TUPE. So it might have to increase prices, for example, if it doesn't get those indemnity protections. And that's often an issue that the customer has got to think about. The customer's also got to flow through any obligations it's subject to under its existing contract in relation to those transferring employees to the new supplier to ensure that they comply, because otherwise the customer's left on the hook and it could be left responsible for potential liabilities that the incoming supplier causes. It's important also not to forget about subcontractors if the supplier is using them to provide the services. If the supplier is subject to obligations or is given rights or protections in respect of all the staff working on the contract and not just its own employees, then those have all got to be flowed down into the subcontracts. A customer's also got to think about managing employees during the contract. So it wants to place some controls on the supplier. Ideally, it's going to want to stop the supplier being able to move the well-performing staff off the contract and poor performers onto it near to termination, or materially changing terms and conditions to the employee's benefit, because the incoming supplier will inherit all those great terms due to the automatic transfer aspect of TUPE. And those are often called anti-sabotage controls for obvious reasons. The customer also needs to include the right to ask for employee information at an appropriate time so that it can complete its retendering processes effectively. Jane's talked about ELI, employee liability information obligation, and that it's really limited in terms of content and often to be provided too late, 28 days before the transfer. So under the contract, this is the way that more comprehensive employee information can be obtained. And finally, the parties in a negotiation often concentrate on the start, on commencement, and they don't think about exit. But it's really important to think about what might happen. Do we expect TUPE to apply? If we do, we need to include the usual indemnity protections. As a supplier, what are you going to do if TUPE is not anticipated to apply, or if it doesn't apply unexpectedly? Would you be looking to ask the customer to cover redundancy costs, for example? And this is going to be more of an issue if you've inherited a lot of people at the start of the contract. Otherwise, you're left bearing the costs of those people. And even if you don't expect TUPE to apply, the customer needs to make sure that it's got adequate indemnity protections in place, because the supplier could change how the services are provided during the term, which could result in a transfer after all. So some reminders then. Where there are people carrying out services or working in a business, you've always got to consider TUPE, even if you don't think it's going to apply. Much better to address any potential issues at the start, rather than being tied into a position later down the road in contract negotiations. If you might be affected by a transfer, it's really important to carry out your due diligence. Look at who's working in connection with the business or the services. Don't forget subcontractors. Are there any risks or liabilities connected with them? Is there anyone on long-term sick? Any potential claims lurking around? Ideally, you want to know about these issues before the transfer. Although the individuals are still going to transfer in most cases, you might be able to agree that the seller or the customer will take responsibility for any potential liabilities that are connected, or to ensure that the outgoing employer agrees to cooperate to enable the incoming employer to handle an ongoing disciplinary issue. Workforce planning is really important. As an incoming or an outgoing employer, who are you going to inherit? Who will you be left with? Will you still have the key employees? Are any redundancy processes going to be needed? It's key that enough time is factored in to carry out the due diligence and the planning processes. A properly run information and consultation process also needs time. If there are no trade unions, then the staff need time as well to be able to elect their reps. So any issues which arise due to TUPE need to be considered at an early enough stage so that they can be dealt with. If there's going to be a need to make redundancies or commencement or pre-sale to make services or a business the right size, then first of all, who's going to pay for these? If it's for the customer's benefit or a buyer in a business sale, they might pay some of the costs, for example. The timing of those redundancies are also important. Often the parties want them to happen pre-transfer, especially where you've got a relocation of the business or services, because this saves time and salary costs post-transfer. But the outgoing employer can't use the incoming employer's fair or ETO reason to make them. So if they're made before the transfer, they'll be automatically unfair for employees with more than 2 years service. You've got to weigh up that risk with the benefit of getting those redundancies sorted sooner. And sometimes it might be better to wait until after the transfer because the risk is going to outweigh the benefit of doing that. But one way of mitigating a risk would be to use settlement agreements to compromise any unfair dismissal claim. But that involves costs. Employees have got to seek legal advice, and usually you've got to pay employees an extra amount. But despite that, it might be worth it if you really need to make sure that those dismissals are made by the date of the transfer. Another issue often arises from the requirement to inform and consult. If you've got to have a transaction happening really quickly for confidentiality reasons, for example, then the parties might agree not to undertake a proper process because the benefit of getting the deal done outweighs the risk. But in that case, the party who takes benefit from the process not being done properly should also take the risk if possible. Another way of mitigating many of the risks I've identified in the previous slides is to get contractual protection. So I've mentioned already that there's a need to ensure the supplier is required to provide employee information during the contract or in the lead up to termination. In a business sale, you're going to get that information as part of due diligence and backed up by warranty. A key way of obtaining protection is by using indemnities. And they're used as a standard market practice to apportion liabilities pre and post transfer, deal with liabilities that might come about where a party fails to comply with its obligations. So that might be information and consultation. And also where there are employees claiming to transfer who haven't been identified previously. You can also use indemnities for any specific risks that you've identified. So to cover the costs of a long-term sickness absence issue, a large amount of accrued holiday entitlement, or an ongoing disciplinary issue. Or it can be used to deal with who's going to cover those potential redundancy costs at the end of a contract if TUPE doesn't apply. There might also be some significant pension liabilities attached to certain employees. For example, that might happen if they've come from the public sector originally. So that could be covered by an indemnity for any additional costs that might result. And we'll be discussing those drafting issues in more depth in June. So the final point I would like everyone to take away today is that the commercial drivers of a transaction or outsourcing are always really important. Employees might just not be the most important factor. Speed of the deal, the value of it might mean that the employment aspects and potential liabilities are secondary. But you've always got to consider that employee risk. So the analysis and decision can be taken in a fully informed way. Now we've just got a few minutes for some questions.
Thank you very much to Hannah and to Jane for that. And thank you to everyone who's been submitting their questions throughout the webinar. So we have a few, and let's not waste any time. We'll kick off straight away. I've been putting them together so that we can hopefully run through as quickly as possible. I'm going to firstly ask Jane. This is a question about ELI. Can the transferor provide a supplementary document setting out other contractual benefits which are not covered by ELI?
They can. There's nothing to stop you supplementing your sort of basic obligations under TUPE. I suppose the only thing I would say is you do need to be mindful in that situation of the data protection obligations, because as you're giving something that isn't required under Regulation 11, then you're going to have to comply separately with data protection obligations, because you won't be within that legal exemption for complying with an obligation under statute.
Okay, we do have another question on data protection as well, which links to whether you need a privacy notice and or explicit consent from employees to give information to the new employer.
Okay, so in an employment context, consent doesn't generally work because of the inequality of the bargaining position. Then relying on employee consent generally isn't the best way to go. It's best to find some other basis for passing on the information. Your privacy notice, the transferor's privacy notice, hopefully will envisage a situation where there's a legal obligation to pass on the information, and you would be able to rely on that. If you don't have a privacy notice at all, then you should probably be remedying that anyway. And certainly if it's a fast-moving TUPE situation and you need to tell people, then I would recommend telling them if it's not already covered by the privacy notice.
Okay, thank you. Hannah, one for you, I think. If an employee transfers in and then there is a redundancy situation after that, which terms in terms of the redundancy package will apply? Is it the old terms or the new employer's terms?
It's going to be the old terms, because the employee transfers across with all its existing rights and liabilities. So the terms and conditions that they're entitled to at the time of the transfer across with them. And so if there's a redundancy process after the transfer, then it's going to be the old employer's terms that are applicable.
Okay, we've got a clarification question on the service provision change test as well. So is it right that for that test, both parties need to be in the UK?
No, that's not the case. For service provision changes to apply, you need to have an organised grouping of employees situated in Great Britain. There's no obligation for the incoming employer to be inside the UK. So what you do end up is a bit of a practical issue. You have TUPE applying, but really what you're going to have is a redundancy, because it's most likely that employees are not going to either want to relocate overseas or not going to be able to. And you might also have a difficulty in enforcement of a TUPE transfer in a jurisdiction where they don't have any sort of automatic transfer legislation. So really what we're talking about is how practically to deal with the redundancy process and who's going to be picking up those costs, and making sure you do that as fairly as possible with consultation, and hopefully getting the incoming employer to take a part. But you know, if they're in a jurisdiction where it's not recognised, they just might not.
Okay, we've got another question linked to redundancy. I think Jane, when informing employees, when do you have to declare during the information consultation process that there might be a potential redundancy situation following the transfer? When do we have to do that?
Well, it's clearly a measure. Redundancy is going to be a measure. So if you're the transferor and you envisage having to make redundancies amongst the staff that you're going to keep, because perhaps there's a shared service and some of the staff supported by that shared service are going to transfer and there's diminishing work for those left behind, then you should be cracking on with that fairly early on in the information and consultation exercise, because you need to make sure there's enough time for that. If you're the transferee, similarly, if you've got pretty settled plans that you're going to need to make redundancies, perhaps the incumbent contractor in a service provision situation has, in your view, overstaffed it, or maybe you've got some different way of doing things that isn't sufficient to mean TUPE doesn't apply, but you just don't need as many people, then you should be flagging that as a measure. And ideally, given that it's protection of employment, you would be engaging with that early on. I mean, sometimes we get asked that it's particularly confidential, people don't want to reveal their plans. And I think as Hannah was picking up at the end, there's always a cost benefit risk analysis to carry out there. You know, what is the real commercial driver for this, and actually is an information and consultation award not actually that important in the grander scheme of things? So it's always going to depend on context, but the general rule of thumb, if you want to be compliant, is to get the information out there earlier than later.
Thank you. I think looking at the time, we probably need to wrap up the questions at that point, which just leaves me to say thank you very much to our presenters, but thank you to everyone who's engaged so enthusiastically with the questions. We're sorry if we haven't reached your question, and there were a number appearing on changes to terms and conditions. We will get in touch with you, but these are the kind of issues that we will be discussing in more detail in our next webinar in June. So we'll send the information out about that together with the slides to everyone who's signed up for this webinar. And please do sign up for that if you're interested. We hope today's been useful, and we hope you'll join us in June. Thank you.